Hey guys, welcome to my legal classes. This is Ganesh Pujari and we were discussing chapter 27 of CrPC, which is on judgment. This particular chapter has as many as 13 sections starting from section 353 to 365. And we already had 5 sessions to cover 9 important sections already, and this is my 6th and last session on judgment covering from section 362 to 365. These are very small sections. Why to waste time? Let's get into the first slide. The first section that we are going to discuss today is section 362, which discusses about court not to alter the judgment. Court shall not alter or review any judgment or final order of disposing a case after its signature. It may be a judgment or a final order of disposing a case. Once after court signing on the same, it cannot alter or review such judgment or order. That is very important aspect as far as section 362 is concerned. Now there are 2 important exceptions that we need to remember. One, the court can correct a clerical or arithmetical error. That provision is available. Or if there is a provision available by this code or by any other law for the time being in force, in that case the judgment or the order can be altered. Otherwise there is no way the court can review or alter the judgment or the final order. I hope that is very clear. If you want me to refer a case law, State of Karnataka versus M.M. Manikandan Nair. Here the Supreme Court held that no criminal court can review its own judgment. I hope that makes it very clear. With that, let's move to section 363. Section 363 discusses about copy of judgment to be given to the accused and other persons. Now this particular section has as many as 6 subsections and all of them are very easy, and I am going to explain all of them. Now subsection 1 says if the accused is sentenced to imprisonment, what happens? Immediately after pronouncing the judgment, the court should provide him a copy of the judgment at free of cost. That's all. That's very simple. Now he is being sentenced to imprisonment. What should the court do? It should give a copy of the judgment immediately after the pronouncement of judgment, and it should be at free of cost. Subsection 2 discusses when an accused desires and applies for a certified copy of the judgment. What happens there? Again, the court should immediately provide him a copy of the certified copy of judgment at free of cost. And if he desires, the court should try to translate the document to his language if it is practicable. Otherwise, the court shall provide the document or the judgment in the language of the court. One more important provision under subsection 2 is if there is any death sentence passed or confirmed by High Court, in that case a certified copy of the judgment shall be immediately provided to the accused at free of cost, whether he makes any application or not. Here it doesn't matter whether he makes an application or not. If there is a death sentence which may be passed or confirmed by High Court, immediately after such pronouncement of the judgment, a copy should be given to him at free of cost. Subsection 3 is the continuation of subsection 2, which says if he desires or applies for the judgment copy in the case of section 117, which discusses about order to give security. If he desires and applies for that, the court shall provide the copy of judgment or order immediately at free of cost. That is subsection 3. Subsection 4 discusses about all those sentences which are death sentences. In death sentence, if there is a right to appeal available, in that case the judgment should very clearly mention that what is the timeline available for such appeal. That is very important, which is covered under subsection 4. All this while we were discussing about the providing of copy to the accused. Now, can anyone other than the accused get a copy of the judgment or order, which is what discussed in subsection 5 and subsection 6. Subsection 5 discusses about all those people who got affected by a judgment or order. If they want, they can make an application and deposit the prescribed charges and get the copy of the judgment or the order or any part of the record. Now, the court can give at free of cost also if there are special reasons available. Otherwise, they have to make payment of prescribed charges. You might be thinking, can someone who is having no relationship with that particular case, who is not at all affected, can he or she apply for a copy? Now the answer is given in subsection 6. Yes, you can also apply for a copy of the judgment or order on making the payment, and by making such payment of fees, you can get a copy of the judgment or order or the part of the record. However, if there is any conditions available, then they have to follow the same condition. Otherwise, they can always get the copy subject to condition. That is what you need to remember as far as section 6 is concerned. Section 364 discusses about judgment when to be translated. Now, if the original record is in a different language than the language of the court, and if the accused requires such document, in such case a translation of documents to be done to the language of the court, and the same shall be added to the record. Now the judgment needs to be translated to the language of the court, and the same shall be added to the records. That is as per section 364. Section 365 comes into picture when the case is tried by the court of session or a chief judicial magistrate. If it was tried by the court of the session, then it should send its finding and sentence to the district magistrate within whose local jurisdiction the trial was held. And if it was tried by chief judicial magistrate, then he should send his findings and sentence, if there is any, to the district magistrate within whose local jurisdiction the trial was held. That's all. With that, I am concluding my sessions on judgment.
Where does it take us?
It will not take us anywhere. We have to choose a new topic and start doing the sessions on the same.
So what are you going to choose next?
That's a tricky question. I think I am going to start sessions on appeal.
Oh my God! Appeal! You are saying that 23 sections are there.
Yes, it's a very big chapter. Chapter 29 of CrPC deals with appeal, and I don't think I can give one session on this particular chapter. We have to go through 3 or 4 or 5 sessions to understand all of them in detail. And I'm telling you, it's very important chapter as a student as well as an advocate. So we are going to focus very significantly on that aspect. Until then, thank you so much for subscribing our channel. Please like, share and comment our videos. All the very best for whatsoever purpose you are watching our video, and see you next time. Till then.